The subject that Alan told me I would be speaking about, enforcement challenges to greenhouse gas emissions in the United States. I thought, well, it's lucky I'm talking at the very end of the program because I can get up and say, hang with me for 2 minutes, I'll be able to discharge you because there is nothing to enforce in the United States, so how can there be challenges? End of my presentation. As they say in the courtrooms, assumes facts not in evidence. So I'm going to briefly talk about U.S. law, Constitution, relationship between the federal government and the states, and judicial enforcement as it relates to federal litigation particularly, and in some cases the way that that state court decisions get appealed and can get up to the federal court. I'll then talk a little bit about the litigation that has been taking place in the U.S. about climate change and why it is so ill-suited, why the vehicles used to address concerns about climate change in the United States are so ineffectual and inefficient to do this job. Then I will get probably to the most depressing part of my subject, which is what has happened in the United States in the transition from the Obama administration to the Trump administration, with respect, of course, to climate change in particular, but environmental and natural resource protections more broadly. And try to finish on an upbeat note. Jokes have never been my strong suit, but there is some bit of reason for encouragement on the horizon. So, with that preface, in U.S. law, there is federalism, and there's been a great deal of discussion about federalism in the last 2 days, which I found fascinating to listen to and engage some of you with, particularly Professor Chalifour, and I believe it was Fenner Stewart in his presentation talked about cooperative federalism in the Canadian context. It's different in the U.S. context because the relationship between the federal government in the U.S. and the states, as well as Indian tribes, is different from, and in some very fundamental ways, very different from federalism in Canada in terms of the relationship between the federal government and the provinces and territories. The U.S. Constitution, which was a long time coming and a lot of blood spilled over, is in many ways, a kind of a compromise reached after an earlier effort failed in the early 1780s called the Articles of Confederation. It was very difficult to give states to give up their power. It was very difficult for the states to allow a federal entity to be given supreme authority over them with respect to matters that they somehow were able to agree were of such overarching significance that it would be to their own individual disadvantages, ultimately, if they did not give up authority over taxation, certain kinds of, well, the right to raise armies, fundamental issues like this. The federal system evolved, has never been comfortable, really, for all the states. At times it has been so supremely uncomfortable that it's resulted in war. But the bottom line is the federal government is a government of limited power and enumerated power. If the power is not provided explicitly in the Constitution for the federal authority, then it is by definition given to the states. Whatever is not given to the federal government is for the states to administer. There are also explicit powers given to the states in the U.S. Constitution, but state government is not regarded as limited authority. The federal government is. Same thing goes for the federal courts. Federal courts are courts of limited jurisdiction. They have chosen, the federal courts have chosen through the U.S. Supreme Court to define what that limited jurisdiction is for themselves. Some of it is explicitly provided for in the Constitution. Lawsuits by one state against another are heard by the federal courts, and the U.S. Supreme Court has ultimate jurisdiction. Lawsuits between the citizens of one state and another state, or the citizens of another state, are federal jurisdiction, because you have different states involved and different citizens of different states involved. But essentially, the federal government, the federal law of the Constitution, is supreme over state law. It's called the Supremacy Clause. It's in the U.S. Constitution. And states are held to have what is called plenary power, general encompassing power, to make policy through their own legislation, subject only to whatever is provided in the Constitution for the federal government, or what explicitly limits them. Having said that, let me talk briefly about cooperative federalism in the U.S. And it's most meaningful, I think, in the context of the federal environmental laws, most of which modern ones were passed in the late 1960s through the 1970s, ending in about 1981. Cooperative federalism in the U.S. is a construct that connotes, in some cases denotes as well, again, federal primacy, federal primary authority in the form of a federal law, a statute which creates a regime of rules, starting out with a statement of purpose, findings of fact in the environmental context. This is the problem we, the Congress, have determined exists. We have determined that it is of such consequence that it needs to be addressed with uniformity across all of the country. Therefore, there is a need for federal law. The Clean Air Act, the Clean Water Act, the Toxic Substances Control Act, the Resource Conservation and Recovery Act, which deals with the management of hazardous wastes from their origin until their ultimate disposal, and everything in between, from treatment, transport, and handling. The Federal Superfund Law is also one of these things. The Endangered Species Act is another one. Federal law is primary. In many of those laws, federal statutory regimes, there is what is referred to as delegated authority from the agency of the federal government, identified by Congress as the agency to write regulations to put meat and flesh and blood, there we go, on those statutory bones. The federal agency, usually the EPA, sometimes the Department of Commerce, sometimes another agency in environmental laws, has the authority to write regulations, in fact, is commanded to write regulations, and then the states, in many cases, are given the authority to implement their own programs corresponding to the Clean Water Act, the Clean Air Act, et cetera, in their own borders, if they wish to. If they don't wish to, then the federal government has the not only responsibility, but the obligation through that agency, the EPA or whichever other implementing agency exists, has the obligation to enforce the federal law as written, as federally written, within the state's borders, in place of the state agency. If the state says, yes, we will have our own program, the federal government is obligated, through the EPA usually, to oversee the state program and make sure that the state can really do what it says it intends to do and wants to do, meaning its laws really do provide for the same mix of regulation that are required under the federal statute, permitting, enforcement, monitoring, et cetera, and that they have the necessary staff and that they train their staff appropriately to actually manage these regulatory programs. Theoretically, and according to the federal law, if the EPA, the EPA is required to do this. And as such, over the last 45 plus years, they have set up programs to interact with the states to make sure that the states are doing this properly and step in and correct, if necessary, enforce against the states, or take back the program from a state which has shown that it's unable to properly implement its own program within its borders. So this is obviously designed as a very interactive process. That's what cooperative federalism means in the U.S. in the environmental law context. Climate change law does not exist in the United States, as I said. There is no federal overarching law that addresses climate change from a thoughtful, comprehensive policy perspective. In 1990, I believe it was, 2009, the House of Representatives passed a bill referred to as the Waxman-Markey Bill. Henry Waxman of California, one of the great specialists in the Clean Air Act, and Edward Markey of Massachusetts, that would have established a cap-and-trade system nationally. The bill did get out of the House. This is 2009. It was the first year after Barack Obama was elected president. The House of Representatives and the U.S. Senate were still both in Democratic hands. But it stalled in the Senate, and after 2010's midterm elections, the Republicans took over the Senate, and the bill died and has never been, not only was that bill not reintroduced, no other legislation to establish federal climate law has even been attempted in the U.S. Congress. So because of this, where individuals, organizations, states, cities have sought federal court help in enforcing climate law or in enforcing regulation of greenhouse gases, they've looked, because they have no other choice, to federal courts. And in 1999, a group of petitioners, including nonprofits, private organizations, as well as cities and states, petitioned the EPA through a rulemaking petition demanding that it regulate greenhouse gas emissions from motor vehicles under Section 202 of the Clean Air Act. The 202 of the Clean Air Act actually gives the authority to citizens to petition the EPA and demand that it do its job as Congress told it to. At this point, EPA had not done anything to regulate emissions from motor vehicle tailpipes. This group demanded that it do so. After 5 or 6 years, it resulted in a lawsuit being filed when EPA said, no, we don't have the authority under the Clean Air Act to do this. We don't have the authority to regulate carbon dioxide emissions from cars or any other vehicles for that matter. We don't have the authority to regulate greenhouse gases, period. And a group of cities and states sued the EPA. That lawsuit ultimately became a U.S. Supreme Court decision, 5-4, in favor of Massachusetts and against the EPA in 2007, Massachusetts versus EPA. The 5-4 decision was swung, as I understand it, late in the litigation because Justice Anthony Kennedy became convinced, he had not been originally, that Massachusetts actually had made a legitimate factual case as to why increased carbon dioxide emissions were at least indirectly responsible for a sea level rise of such acceptably quantifiable levels that Massachusetts was already suffering economic harm because of loss of some of its seashore, and that problem would only get worse. And therefore, Kennedy decided to vote in favor of the plaintiffs and swung the decision 5-4 in favor of demanding that the EPA either regulate or explain why it could not. EPA initially decided that it would try to persuade the courts that it could not. That didn't work. And after the Bush administration left office, EPA decided that it, in fact, would make a determination that carbon dioxide emissions from motor vehicles created an imminent and substantial endangerment, that's Clean Air Act language, an imminent and substantial endangerment to public health and the environment, and began to actually regulate. That case remains the distinctive case of climate change litigation in the United States. Within 2 years, a differently constituted U.S. Supreme Court, without Justice Stevens and without Justice Souter, but now with Justice Alito, voted 5-4 to uphold the endangerment finding. Carbon dioxide is a greenhouse gas that EPA can regulate, but it struck down a central EPA effort to regulate carbon dioxide and greenhouse gases from stationary sources in this 2-year later decision, United Air Regulatory Group versus EPA. A decision, frankly, which can only be explained by the addition of new justices and subtraction of other justices who had been in the majority in the Massachusetts versus EPA decision. The majority decision in the Utility Air Regulatory Group decision was written by Justice Scalia, who had been the most, well, he's always the most eloquent, no matter whether he's writing the majority opinions or dissenting. The most eloquent opinion dissenting in Massachusetts versus EPA, when among other things he said in response to his indignant response to EPA's decision that carbon dioxide was a, quote, pollutant, unquote, under the Clean Air Act. He said, if carbon dioxide is a pollutant, then everything from frisbees to flatulence is a pollutant under the Clean Air Act. This is absolutely ridiculous. You can't possibly regulate. Well, now he's writing majority opinions after this. I want to quickly talk about standing to sue. This is a term, I don't know if it exists in Canadian law. Owen is nodding yes. It's a threshold requirement. You can't get into court. You can't get into a federal court unless you can prove that you not only have a legitimate case, you have been harmed in some way, but you have to prove there are 3 tests to show that you have standing to bring the lawsuit, and therefore to get the court to listen to you and to render a decision. You have to prove that you have been harmed in a tangible, concrete way, and that the harm you have experienced is particularized. You have suffered an injury that is special to you. Doesn't mean that no one else can have suffered that injury, but you have to be able to describe the injury that you have suffered in a particular way that impacts you, as well as it being a concrete way, a tangible, real way. And you have to show that the harm from that injury is actual and imminent, not conjectural or hypothetical. That's the first test. Second test is you have to show that the injury you suffered, that you've described before, is fairly traceable to the conduct of the person or the entity that you've sued. You have to make a connection your injury was proximately caused by the defendant who you've sued. The final one is arguably the highest barrier to cross, that the injury that you have suffered, that this defendant or defendants caused, or probably caused, is an injury that can be redressed or remedied by a favorable decision of the court, which means that you've got to be able to answer the judge's questions. What do you expect us to do about this? Even if you're right, what can we do? What possible remedy can we fashion that would make you whole or compensate you for the damage that you've suffered? In Massachusetts versus EPA, and this is significant because state lawsuits against the federal government in the absence of climate change law become more important with time rather than less, and particularly so in the Trump administration with its assault on climate science. The U.S. Supreme Court in Massachusetts versus EPA took a very tortured path to finding that Massachusetts had standing to sue the EPA, alleging that it had suffered as a state the kind of damage that could be remedied by EPA's writing this regulation to control carbon dioxide emissions from motor vehicles. And what the doctrine that the Supreme Court used was that when the states joined the Union and gave up complete sovereignty to the, not complete sovereignty, but total sovereignty to the federal government to allow the federal government to actually exist, they retained certain sovereign, what were called quasi-sovereign rights. And that one of these was this, let me see where I have the exact term. Well, it's not critical. That Massachusetts could assert in its role as a state that had retained certain rights not given up to the federal government, and those rights were not specified by the court. This was a case that went back to, in fact, the citation used by the court to support this standing doctrine in Massachusetts versus EPA was an 1830 lawsuit by Georgia against Tennessee, where Georgia was claiming the right to enforce against Tennessee certain actions taking place in Tennessee that endangered certain forests in Georgia. And the doctrine was first articulated in the 1830s by the U.S. Supreme Court to say Georgia has the right to protect its own resources against harm from Tennessee. In the same way, they said Massachusetts has the right to assert protection of its seashore against the federal government to require EPA to regulate greenhouse gases. This is a doctrine of standing that was attacked vehemently, both by Chief Justice John Roberts in a dissent, by Scalia in a separate dissent, and therefore is now that, although Scalia died, with the two new justices that Donald Trump has appointed, Neil Gorsuch and Brett Kavanaugh, both of whom are very strict constructionists and who have said things about standing in federal cases like this in their earlier decisions, Gorsuch when he was on the 10th Circuit Court of Appeals, Kavanaugh on the District of Columbia Court of Appeals. There is really legitimate reason to be concerned that there is now a 5-justice majority that would be very skeptical, to put it mildly, of this kind of authority of states to sue the federal government in their role as either parens patriae, the father of their children, or in this quasi-sovereign capacity. It has yet to be determined. There is no case pending before this new court yet that would be a test, but commentators across the board are expressing skepticism and concern that Massachusetts might not be able to get in with this new court the way it's constituted. I'm going to shift gears a little bit and talk about what has passed and does pass for climate change law in the U.S., just to give you a feel for why it's not effective and how we hurt from not having what you've got here in Canada. When I look at GPA, GGH, PPA, GHG, PPA, I think that there are sugar plum fairies dancing in front of my eyes, and I wish that that history was different. Hopefully it will be. The best examples to use are the Clean Air Act, the National Environmental Policy Act, or NEPA, and the Endangered Species Act. I'm not going to talk much about the Endangered Species Act at all. I'm going to focus a little bit more on the Clean Air Act and also on the National Environmental Policy Act, just to show you how climate change issues get litigated in those cases. The Clean Air Act, it makes the most sense, obviously, of all federal statutes because we're talking about air emissions when we talk principally air emissions. When we talk about greenhouse gases, there can be migration of gas through soils into structures, but those aren't greenhouse gas emissions. The Clean Air Act regulates by either specification of a particular pollutant that is believed to cause an imminent or substantial endangerment or public health hazard, that is the principal way that the Clean Air Act regulates, and it also regulates according to where that particular contaminant or pollutant comes from, whether the source is stationary or mobile. And there are different standards depending upon what the nature of the source is. But there has to be, for the Clean Air Act, there has to be a source that can be identified as the generator of this contaminant. When it comes to greenhouse gases, if you're trying to enforce controls, you have to go with carbon dioxide or target methane, but you have to focus facility by facility, source by source, discrete source by discrete source. That's the way the law was written. With the National Environmental Policy Act, what I like to call the mother of environmental laws, the keyboard of environmental laws, if you think of an orchestra. The National Environmental Policy Act requires an environmental analysis, assessment, impact statement where there is a proposed federal project that could have that requires, it says, quote, major, unquote, federal action, that proposes major federal action, which action could have again, keyword, significant impact, adverse impact on human health or the environment. The environment meaning either man-made or the natural environment. Every single federal project that proposes a major action and every agency of the federal government is required to promulgate its own NEPA implementing regulations for how it will apply NEPA's requirements for environmental assessments to every kind of project it engages in, without exception. Every single federal agency has its own NEPA guidelines. And the President's Council on Environmental Quality has issued guidelines to help agencies identify how to develop their own regulations for assessing when their projects or projects they propose to approve will require different levels of environmental analysis. What's important to know about NEPA is that when it contemplates an environmental impact statement to be used to evaluate what the significant impacts of a major federal action might be. It only requires, and this is what it was designed for, it only requires transparency in the identification of those significant adverse environmental impacts and what could be done either to eliminate them altogether or, conversely, to mitigate them to a level of, quote, insignificance, unquote. It does not, however, prevent the agency with approval power over the project from approving the project, even though there are and may be unmitigated adverse environmental impacts. It requires that the decision makers be transparent about what the impacts are, require the project proponent, whether it's an individual, a company, or the federal agency itself, to identify the adverse impacts and require the agency, the project proponent, to show how those impacts could be mitigated or ideally eliminated. But again, the project may be approved even in the face of unmitigated, potentially significant adverse environmental impacts. In the context of climate change, one example of what this means comes out of a case from 2008, the Center for Biological Diversity versus the National Highway Traffic Safety Administration, when the Bush administration's Traffic Safety Administration, George W. Bush, promulgated a rule to set fuel efficiency standards for small trucks and SUVs without considering any alternatives to its proposed rule that would reduce greenhouse gas emissions from that class of vehicles, or those classes of vehicles. The Ninth Circuit Court of Appeals, which is where the lawsuit was brought by the Center for Biological Diversity, held that those emissions are collectively significant over time, even though any particular fuel efficiency rule by itself might have only a minor effect, and therefore required the National Highway Transportation Safety Authority to, quote, provide the necessary contextual information about the cumulative and incremental impacts of the final rule in light of other rulemakings and other past, present, and reasonably foreseeable future actions, regardless of what agency or person undertakes such future actions. So it's a recognition by the court, federal court, that greenhouse gas emission impacts can be inherently incremental, and that no rule which purports to regulate greenhouse gas emissions, even in a small context, can ignore those impacts because of the cumulative effect over time, and even the fact that there is a jurisdiction to continue to regulate in the future that may add to this body of regulations. You have to contemplate that. In other words, nothing is too small. Again, what this means is you've got to study it, you've got to analyze it, you've got to quantify it as best you can, you've got to talk about the adverse impacts that these emissions will have, and then you've got to identify ways that you can devise that are reasonably practicable, technologically feasible, to implement them so that they will be reduced. It does not, NEPA by itself, give anyone an enforcement right other than, again, to require this document to disclose all environmental impacts. The biggest change in U.S. law, and this is something that has been going on for some time and is now in the next stage of its development, is what was under the Obama administration called the Clean Power Plan, that Donald Trump, as a candidate, announced his intention to scrap on day one most of what he saw his base Wanting, he promised he would do on day one. It gave some of us a vision of the création du monde. On the first day, Trump destroyed this. On the second day, Trump destroyed that, and et cetera, et cetera. And on the seventh day, of course, who knows? In any event, the Clean Power Plan was a full-throated embrace under President Obama of the need to control greenhouse gas emissions from electricity-generating power plants, not just coal-fired, applying both to new and to existing modified facilities. It set performance standards. It set different methods of meeting the performance standards for new facilities than it did for existing ones. It was, to be sure, primarily directed at coal-fired electricity plants, because that's where most of the emissions came from, but it was, as I said, not limited to that. And for purposes of comparing the now former proposed, it never was enacted, proposed Obama Clean Power Plan with the current proposed, not yet enacted, Trump affordable, it's called the ACE rule, Affordable Clean Energy Rule. This is the completely counterintuitive term used by the Trump administration to describe its replacement for the Clean Power Plan. What you have is a problem with the rules applied to existing plants. The Obama administration's people realized that they could not devise a set of performance standards that would be uniform across the board to be applied against all existing facilities that could be retrofitted to any degree, and therefore set up a very, and I'm not an expert in energy law, but it was a very, not so much convoluted as wide range of options by which companies could, with existing plants, could make changes that would meet these performance standards to reduce emissions. They called them 3 different building blocks. One building block was efficiency improvements in coal-fired plants. Number 2, substitution of natural gas generation for coal-fired generation when feasible. And number 3 was increased use of renewables. And because EPA determined determined nationally feasible emission reductions by applying each building block within each of the 3 interconnected U.S. power grids, it used a lowest common denominator for each building block to set a national standard. That is the very method that the Trump EPA singled out in the preamble to its new Affordable Clean Energy Rule as why the Obama administration had exceeded its regulatory authority and why it, the current law-abiding Trump administration EPA, could not allow this realm of regulation to exist, and why it was not going to continue this. The reason is the Clean Air Act does not deal with power grids, does not contemplate regulation that applies to power grids. Apparently, none of the energy laws, and I don't know energy law well enough to talk about this, but that has never been an issue that has been raised as there would be possibly other statutory authorities to do this with, because coal-fired plants were the ones most subject, most vulnerable to this Obama Clean Power Plan building block rule for getting existing plants to comply with the law. and because those rules that the Obama administration proposed were the ones that stretched the Clean Air Act further beyond its existing structure, they were the most vulnerable to change. And there's some litigation here that will be relevant to what's been going on recently. I had a conversation with a couple of you about the lawsuit Juliana versus the U.S., a climate change lawsuit brought by children under the auspices of I believe it's Save Our Children, an NGO, against the Trump administration. Well, it was brought during the Obama administration. Our Children's Trust is the name of the NGO, brought in federal district court in 2015 in Oregon by 21 children across the United States, alleging constitutional and public trust doctrine grounds as to why the U.S. federal government had violated the children's rights by failing to take necessary dramatic steps to control greenhouse gas emissions and implement urgent climate change measures. Both the Obama administration and the Trump administration sought appellate court intervention to stop the lawsuit from even getting off the ground. There were, I believe, 3 previous efforts, one in the Obama administration, one in June of last year, in June of this year, maybe one in 2017 under the Trump administration, another one in June of this year. All 3 failed. 2 to the federal courts of appeal, which refused to stop this lawsuit. And then the one most recently was 2 weeks ago. But in June of this year, the Trump administration petitioned the Supreme Court through the Ninth Circuit to stop this lawsuit from going forward on the grounds that it had absolutely not only did it have no chance of success, but that it was a waste of precious federal judicial resources and was so preposterous on its face that it needed to be dismissed immediately. Justice Anthony Kennedy was the Supreme Court justice assigned emergency petitions from the Ninth Circuit. Every U.S. Supreme Court justice is assigned the responsibility for hearing emergency petitions from a particular one, in some cases 2, federal circuit courts of appeal. Because this came out of Oregon as part of the Ninth Circuit, Justice Kennedy got the Trump administration's first petition to stop the lawsuit, and he refused to grant the petition. Although he did say that it posed constitutional questions of uncommonly wide breadth, or some similar remark that indicated he probably would not vote for it if it ever came to him on appeal. But he refused to stop the trial. Last Friday, Chief Justice John Roberts granted that petition to stop the trial. The case came to him because, again, it came through the Ninth Circuit. It was another effort by the Trump administration to stop the lawsuit. It came to Roberts because Kennedy was no longer on the court. Now, last week, Brett Kavanaugh had already been appointed as the new Supreme Court justice, but had not yet been assigned a circuit court of appeals to be the monitor for emergency actions for. So Chief Justice Roberts assigned this latest effort to stop the Juliana versus U.S. case to himself for the Ninth Circuit and granted it with a request to the plaintiffs that they provide him with an answer by 2 days ago, so 5 days after his grant of a stay, as to why he should change his mind. My understanding is that on October 24th, the plaintiffs did in fact submit a 109-page response to Chief Justice Roberts. He is under, as far as I know, no deadline to respond to this petition or to their answer, but he does have a choice when he does of either ruling on his own to deny it or to grant it, or to give it to the entire Supreme Court, all 9 justices, including himself, to evaluate. What's interesting is that the same day, last Friday, that Chief Justice Roberts decided he himself would hear this emergency petition because Justice Kennedy, who had controlled the Ninth Circuit before, had retired. He appointed later that same day Brett Kavanaugh as the new Supreme Court justice in charge of emergency petitions from the Ninth Circuit. So the timing is curious, to put it mildly. This is significant because it is yet another example of intervention by the U.S. Supreme Court in pending federal court litigation to stop lower courts from doing their work I'm not being coy, for unannounced reasons. Chief Justice Roberts' decision in the U.S. Juliana case was not explained either by narrative rationale or by citation to any federal authority, by which I mean any case law. Obama's Clean Power Plan was attacked in the courts before the rule. Well, it never became final because of the Trump administration, but while it was still a proposed rule, a number of states, led by West Virginia, sued in federal court to stop the rule from going through the regular regulatory process because they claimed, and the utilities who joined state West Virginia in the lawsuit claimed, they were already suffering irreparable harm just at the prospect that this rule might become law. And interestingly enough, the appeal of this lawsuit on the Obama Clean Power Plan in June of 2015 went to the District of Columbia Circuit Court of Appeals because it was an appeal of a federal agency rule. The District of Columbia Court of Appeals hears directly all appeals of federal agency rules, wherever they're from. The opinion was written by Circuit Judge Brett Kavanaugh, who wrote, just to show you he does have limits, he wrote, quote, "Petitioners want us to do something they candidly acknowledge we have never done before. Review the legality of a proposed rule," his italics. In justiciable cases, this court has authority to review the legality of final agency rules. We do not have authority to review proposed agency rules, unquote. Petition denied. So this was in 2015. In 2016, Donald Trump is elected president, new administration, new EPA, lawsuits. EPA publishes a notice of its intention to formally repeal the Clean Power Plan in its entirety on October 16th of 2017. On December 28th of 2017, it published an advance notice of proposed rulemaking for emission guidelines to limit greenhouse gas emissions from electricity generating units. And on August 28th of this year, 2 months ago, barely 2 months ago, it published its proposed Affordable Clean Energy Rule to replace the Clean Power Plan with revised emission guidelines, important quote here, that inform the development, submittal, and implementation of state plans to reduce greenhouse gas emissions from certain electricity generating units, unquote. Certain ones. And in fact, this rule applies to existing units, does not purport to regulate new power units, power generating units that generate emissions. On February, so back again now to the Obama administration to make this connection to the U.S. versus Juliana versus U.S. Supreme Court intervention in ongoing lower federal court proceedings. February 9 of 2016, after Kavanaugh on the D.C. Court of Appeals refuses to stop the Clean Power Plan, 27 states petition the Court of Appeals again for a ruling to stay the implementation of the Clean Power Plan while their appeal is being heard. And on February 9th of 2016, the U.S. Supreme Court grants petitions filed with it directly by 5 parties to stop the lawsuit in the District Court of Appeal. To stop implementation of any parts of the Clean Power Plan while the Court of Appeal is hearing the lawsuit that it's unconstitutional. The 5-4 vote was written by, let's see here, I want to make sure I got this right. Written by Justice Scalia. The 5-4 majority was the same 5-4 majority that a year earlier, or 2 years earlier, had ruled against EPA, expanding the Clean Air Act to deal with emissions more broadly, greenhouse gas emissions, than just from automobile tailpipes. And 5 days after Scalia led the court in a stay of any further regulatory action on the Clean Power Plan, he died of a heart attack, apparently. That was his last decision. And after that, as you probably know, the Republican-controlled Senate, led by Mitch McConnell of Kentucky, refused to hold hearings, let alone take a vote on Barack Obama's nomination of, ironically again, Brett Kavanaugh's boss, the chief judge of the D.C. Circuit Court of Appeals, to replace Justice Scalia. When Trump was elected, one of his first actions was to appoint Neil Gorsuch to replace Scalia, and then, most recently, Brett Kavanaugh. Both Neil Gorsuch and Brett Kavanaugh are strict constructionists and now truly cement a very, very anti-regulatory, limited federal government majority on the Supreme Court. The Trump administration's Affordable Clean Energy Rule is best described as a non sequitur. Not only does it elevate coal above all other sources of energy, but the fact that it does so is evident from the way in which utilities responded to it when it was first proposed. Utilities that relied almost not at all on coal for their power excoriated the Trump administration for backing off of the forward-looking progress that the Clean Power Plan had promised. Utilities, as an example, Pacific Gas and Electric in California and National Grid US, which have no coal-fired power plants, strongly disapproved of Trump's new rule. Well, utilities that continued to rely on coal-powered energy for most of their plants embraced the rule. Ironically, utilities like American Electric Power, Southern Company, and First Energy Solutions in the U.S., which rely mostly on coal power, while they embraced the Trump rule to bolster coal-fired power plants, within a week after the announcement of the Trump Affordable Clean Energy Rule in late August, announced the closure of 3 or more of their own coal-fired plants, and one of them announced for it, very bold strategy for decarbonizing its entire operations. So if there's any indication that they know what's coming but are trying to avoid paying the price, that's the obvious reason. That's the obvious explanation. There is and there are a couple places where you can get good reviews of this rule. There are some, and in my paper at footnote 25, I give you the ways to identify the figures and charts and tables in the Trump Affordable Clean Energy Rule where you can look at these data. It's sort of hiding in plain sight, but the Trump rule says that it will lead to 1,400 premature deaths if it's enacted, that it will cause 15,000 cases of new respiratory ailments if it's enacted, and will cost billions of dollars in increased sick days, missed school days, higher medical expenses, lost wages, and other harms. Its maps clearly show that the highest rates of these additional deaths, increased expenses, and social costs will occur in a band beginning in the Midwest and running east into West Virginia and southern Pennsylvania. The public comment period on this rule closes appropriately on Halloween, and it is legitimately expected that there will be lawsuits filed in federal court probably on November 1st or certainly in the first week of November to prevent this rule from becoming enacted. I'm going to finish with one example of why it is so breathtakingly, what's a good non-neutral word, challenging to be an environmental lawyer, activist, or I'll stop there, in the Trump administration. The Obama administration Barack Obama had written an executive order dealing with floodplain management and emergency rules governing how to deal with flood-prone areas. One of Donald Trump's executive orders, here we go, 13807, written in 2017, explicitly revoked Obama's previous executive order, which Obama's had, established a new flood risk management program. Lost in 1 second here. Okay, sorry for the delay. The Obama executive order, and by the way, executive orders cannot change existing law. They cannot change the rights of any individual or any entity under any federal law. All they do is they change the behavior and or the operation of federal agencies and federal employees. That's the limit of a presidential executive order. It's usually considered a consolation prize when Congress won't do what you want. So you get at your own employees in the executive branch first by writing an executive order which only implicates them and their agencies. So the Obama executive order addressed the need to improve the resilience of communities and federal assets against the impacts of flooding that are anticipated to increase over time due to the effects of climate change and other threats, quote unquote. A new federal flood risk reduction standard was called for by the executive order with input from governors, mayors, and other stakeholders. It required, quote, that the floodplain, definition of floodplain in all federal law and with governor's help in state laws as well, a new definition of floodplain across the United States would be, quote, the elevation and flood hazard area that result from using a climate-informed science approach that uses the best available actionable hydrologic and hydraulic data and methods that integrate current and future changes in flooding based on climate science, unquote. Trump issued an executive order in March of 2017 explicitly revoking that Obama executive order, not substituting anything in its place. And you rarely ever see this in the federal government, certainly on a website. The Army Corps of Engineers, which is responsible for floodplain management and dam building and dam destroying when they want to, after Trump's executive order was issued, wrote on its website, quote, there will be no further development or any implementation of the draft engineering circular which had been prepared to implement EO, the Obama executive order. To learn more about the federal flood risk management standard and how the Corps intended to implement these new requirements, explore the sections below, unquote. Those sections no longer exist on the Army Corps of Engineers website. They've been scrubbed by the Trump administration. It's as though the Army Corps of Engineers were writing a requiem mass for its own stymied, forward-looking regulations. And I'll finish with this. 10 days after Trump signed the executive order wiping away this, widely praised emergency floodplain management executive order, 10 days after Trump revoked it, Hurricane Harvey struck the Texas coast of the Gulf of Mexico, stalling over Houston and dropping a record U.S. continental 51.88 inches of rain over the Houston area, covering 70% of an 1,800 square mile county to a depth of 18 inches. The estimated financial cost was between $125 and $180 billion, second only to Hurricane Katrina in dollar volume of damage. 800 wastewater treatment facilities and 13 Superfund sites were flooded. 12,700 homes were destroyed, and approximately 88 people were killed. A climatologist at the University of Wisconsin's Space Science and Research Center calculated that the volume of rainfall within such a short period of time exceeded any storm in recorded history. I'm also read in one source that NASA documented a depression in the curvature of the Earth for almost 18 hours as a result of the volume of rain ponding over Houston, on top of Houston. God speaks in many ways. When we use the term act of God in the law, we obviously refer to acts that are damaging, not acts which are beneficial. Certainly, Hurricane Harvey was an act of God, but for many of us in the United States, it was an act of God with a particular kind of message that we hope we will be able to to carry forward over the next, hopefully only 2 years, but possibly 6. It's hard to imagine. My point is this, that, and I'm again, maybe valiantly but ineffectually trying to add some levity to this conclusion. There has never before been as unprecedented an assault on public health, science, and the environment in the modern era of the United States. Nothing even comes close. There is a deliberate, with malice aforethought, if you believe in the integrity of regulation, malice aforethought, effort on the part of the Trump administration's agency chiefs and assistant administrators, bankrolled by oil and gas companies, coal first and foremost among them, but by no means limited to coal, to wipe away as much of Obama's record in climate change regulation and laying a framework for climate science to become a basis of possibly new federal legislation that is unfortunately successful enough that it has thrown a complete wrench into virtually everything which the Obama administration had started doing. Scott Pruitt barely got through the Oklahoma jurisdiction that he was in charge of when he was Attorney General. He was totally out of his depth in Washington, D.C., had never had any federal experience, and it showed. He made a mess wherever he went. He couldn't even get rid of rules properly. Andrew Wheeler, his replacement, is an expert at this. He was a 20-year lobbyist for the coal industry. He was a legislative aide to Senator James Inhofe of Oklahoma, who once brought a snowball onto the U.S. Senate floor to prove that climate change was a hoax. And Inhofe himself has bankrolled Kavanaugh's Supreme Court promotion and fighting off opposition. So the lines are clearly drawn. This is a battle, and all I can say is that we are now looking north to you all as an example of ways that there might be a comprehensive greenhouse gas pollution prevention act or plan, notwithstanding our structural differences, and despite the Senate Republican leaderships and Donald Trump's expressed statements, science is real. Science is common to the entire world, and science is fact. And hopefully the United States will recover its sanity. And thank you for this opportunity. Please pray for the United States of America.